Great. Hello, everyone, and welcome to the SB 354 webinar. Thank you so much for taking the time to join us today. My name is Emily Smelson. I'm a project manager here at the Children and Family Services Division at CDSS. I'll go over a couple of items right now, and then I will hand it over to Kim Wrigley, our presenter today. So as I just mentioned, today's webinar is being recorded in the event any of your colleagues may have been unable to attend. And once it's been made accessible, we'll get the recording posted to our CDSF YouTube page. So anyone can access it there. So if there's anything that you want to refer back to, that should be available in the next couple of weeks on the YouTube page. And this process generally takes about 2 weeks for it to be made accessible and then to be posted. So just be on the lookout in a couple of weeks for that. Today's webinar is a WebEx event. So this means that if you are not a panelist, you will not have the ability to unmute or turn your camera on. But if any questions arise during today's webinar on what's being presented, or if you have any questions about the slides or anything, please just enter those into the chat. I'll be keeping an eye on that so we can get back to you on that. And when you look at submitting questions, you have the option of submitting it to the all panelists or the host and presenter. Please just submit it to all panelists so that we're all able to see the questions that are coming in. And if time allows, at the end of today's presentation, Kim's team will answer some of those questions that were raised in the chat. If we don't have time to get to all of them, we're going to take any unanswered questions that come in, and we will work on a response for the group. Those questions and responses will be added to the FAQ document that Kim's team is working on. Once that document is ready, I will send that out to everyone that's on the webinar today. So we'll send that back out to this group. So yeah, I think that that's mostly what I needed to cover. Again, I'll be monitoring the chat throughout today's webinar. So please just let me know if you have any questions or if you're experiencing any technical difficulties. We will be sharing out the PowerPoint that's being shared right now. We'll share that out after the webinar with this group so you can access it going forward. Just thanks again to everyone for taking the time to join us today, and I'm going to hand it over to Kim.
Good afternoon, everyone, and thank you for joining us. My name is Kim Wrigley. I'm the Chief of the Resource Family and Eligibility Services Bureau here at the California Department of Social Services. We, along with many of my teammates and peers across CDSS, were involved in helping develop the guidance once SB 354 was developed. So we'll try and go through here. I'm sure there will be questions that we may not be able to answer today. And like Emily said, we will get back to you as soon as we can with that. When we're going through this PowerPoint today, it's very important that when you see the word relative or applicants or non-related extended family member, that we're very deliberate in our usage of these words. So if we're saying relative, that means that whatever the topic we're talking about only applies to relative. And that's really important as we go through SB 354, as so many areas impacted all families, all applicants, some impacted only relatives in a variety of ways. So we'll discuss that as we go through this. Next slide. So I wanted to talk a little bit about what was the intent of SB 354. We had some amazing sponsors and authors who really had this idea that they really wanted to put forth some legislation that would minimize the barriers to approval for relatives. They understood through the work that they did that oftentimes we have these wonderful families coming forward, or maybe they've accepted placement or are trying to accept placement of a child going through foster care. And because of something in their criminal background history that was there, impacted their ability to be approved as a resource family. So really, the intention was to open some doors for families, appropriate, wonderful quality families to care for children in our foster care system. In doing so, they thought it was important to clarify some of the authority, the court authority for placements, and ensure that when these families are able to receive placement, that their financial stability or their lack of resources is not impeding their ability to receive a placement. It was very important that as we're opening some of these doors and understanding some of these doors that were being opened may impact different funding options that were available to all families, but particularly relatives. So they wanted to establish some legislation to ensure that funding was available to them. So doing so, part of what they did is really aligned California's non-exemptable crimes list with the federal standards, which is commonly known as the Adam Walsh Act. When Adam Walsh Act came to be and California implemented their own statutes regarding those non-exemptable crimes, California had actually gone much further than what the federal standards were. So California had added additional criminal convictions to their list. So what we were really doing was bringing 354 back in alignment with what the federal standards had been. And then really the bottom line is just doing so, we're going to increase the number of relatives who are eligible to be considered for a criminal record exemption. As we go through this webinar today, I just really wanted to point out that there are really three major buckets to SB 354. We'll be talking about all of these. So this is why this really was a department-wide effort to put forth ACL 22-33 to provide the guidance on this bill. Is it really impacted many areas of our department that were really going to help children and families in our foster care system. So changes were made to the placement process, approval, and the funding. Those are the three major buckets that we'll be talking about today. Next slide. So before we really dive into the meat of SB 354, we thought it was really important to remind everybody about why this was so important to open up some of these barriers and open up some of these opportunities to relatives. And that was because of all the legislation and all the data and support and research that has been done about the importance of children being placed with relatives. And so we have a lot of legislation. We've just listed a little bit here about where relatives should be given preferential consideration for placement. It's in more than one statute. So we just listed a couple here. And in terms of Indian children, it's very clear that the first preferred placement priority is a member of the child's own extended family. So over and over again throughout the Welfare and Institutions Code, it is really stressed, again, based on research, that a child is going to fare better, have a better opportunity with success if they are placed with a relative. And with Indian children, we always want to remember that the collaboration and communication needs to occur with the tribe before any placement decisions are being made. The very moment that you have an ICWA eligible child come into your caseload, into your realm, the tribe should be involved right from the get-go. And sometimes we know that's difficult when working with tribes, that they may be located geographically a far distance away, or they're not able to meet with you. So really exploring different ways to involve the tribe, whether it's joining virtually through more phone calls, that it doesn't always have to be an in-person meeting. I think also, some of the fabulous data we've looked at recently, we've gotten a lot of indicators that show that currently in California, 75% of the youth that had their first placement with a relative and are still in care let me say that again. Their first placement, 75% of youth were with a relative, and those children are still in care at the 12-month mark with that same relative. So I think that really shows a lot of the success of all the work that all of us have been doing in the last several years with the continuum of care reform and the resource family approval program, really ensuring that we're opening up the home-based care opportunities, particularly for relatives. Okay, so we'll go ahead and dive into SB 354 here. So really, when we're looking at court authorized placements, there were not significant changes made to the already existing practice. What really the bill did was enhance and clarify some of these components. So the juvenile court has always had the authority to make placements with relatives. They just clarify that this can occur regardless of the criminal history or the denial of the resource family approval program. But when the juvenile court is doing so, they also must determine that the placement does not pose a risk to the health and safety of the child, and that if the emergency placement occurs, the relative must initiate either the tribally approved home or the resource family approval process. When you do have an ICWA eligible child, it is important to have that conversation and collaboration with not just the county, but with the tribe and the caregiver as well, so that all of the entities involved can determine whether the tribally approved home or the RFA process would be the most appropriate process for that caregiver to go through. It's also important to note that the relative does have the right to apply for RFA or to work with the tribe for consideration as a TAW, even when the county or the court has determined an emergency placement could not be made. So this is really important to note that there are situations where a child was not able to be placed with a relative when they were first taken into care, but that does not preclude them from being able to initiate the process. So if an emergency placement worker said, no, sorry, we're not able to make that placement right now, they still have the right to apply for RFA or to work with the tribe and move down that process, because that was a placement determination that was made at that point in time, and they had not had an opportunity to apply yet to be approved as a resource family. So we say that throughout the RFA statute, and that's why I like to hone in on that, to really emphasize that placement decisions and approval decisions are separate. So placement workers need to make placement decisions based on all the information they have about the child, where the RFA staff or the tribal staff looking at the tribally approved home, they're really making decisions and assessing a family for their overall ability to be approved based on the family history, the family evaluation. And then the two would work together to determine whether that child is the right placement, or that family is the right placement match for that child. Next slide. So the emergency placement process with 354, really wanted to point out, and I'm not going to read everything on this slide, nothing has changed with the actual inspection, the actual assessment for an emergency placement. The only part of the emergency placement process that has changed is what you see here that is in bold and is italicized. It requires the county of jurisdiction to make reasonable efforts to assist the relative or the non-related extended family member in acquiring the necessary items for placement of a child. So you're still doing that brief in-home inspection. The CLETS check is still being done. You're looking at the CACI. All of these items are still occurring the way they always did. But when you're doing that home inspection, if you're discovering that there's a few things that need to occur before this emergency placement can happen, it's upon the county of jurisdiction to make any reasonable effort to help them acquire those items so that you can secure that emergency placement of a child. The other part, I think, are you able to scroll down a little, Emily? I think that last bullet got cut off a little bit. Or is that, oh, I'm sorry, technology. I had made my screen bigger, which cut off that last bullet. I apologize, everyone.
Okay.
The last bullet there, the court may still authorize an emergency placement regardless of the CLETS results or the county's recommendation. So this is really important to understand, that when a relative is being considered for the emergency placement and the county has done their home inspection, they've done their CLETS and their CACI checks, they will inform the court of the results of that. They'll make a recommendation for a placement to occur or not to occur. And the court may still authorize that even if it goes against the county's recommendation. Okay, next slide. Okay, sorry, I'm looking at my notes here. So what we see here, there was a lot of changes that occurred in SB 354 regarding the criminal background checks. And this is probably where the most change has occurred within the legislation. So we do have at the end of this webinar today a list of the different resources with hyperlinks to access a lot of the documents or a lot of the information we're sharing today. One of the most important pieces for everyone to become very familiar with if they're conducting a criminal background check on an RFA applicant, or for a tribe if they choose to utilize this guide, is the background assessment guide, the Resource Family Approval Background Assessment Guide. It is what is to be used. It's the sole guide for all RFA background check procedures. Now, tribes may also utilize this as a guide when they're conducting their own background checks on behalf of the tribe, or counties may also use it when they're doing it on behalf of a tribe. So tribally approved homes and RFA are subject to the same standards for criminal background checks for foster and adoptive placements. And it's all based on statutes and the Health and Safety Code in order to receive the 4A care maintenance payments. Tribes can continue to choose not to complete their own background checks, but they may request the county or CDSS to do so on their behalf. In either case, when criminal background check is being done, the RFA background assessment guide is really one of the most important tools you can use when you're receiving the live scan results and you're assessing whether an exemption is needed or not and what process you need to go through for that. Even within our own department, for an FFA, our Care Provider Management Bureau will also utilize the background assessment guide for FFA resource family applicants. So here's where we're going to talk a little bit more detail about what those criminal record exemptions look like. So this first slide that we're going to talk about, this applies to any applicant. So this is for any applicants going through RFA or through the tribally approved home process. In terms of the actual steps required to complete an exemption, nothing has changed with that, whether it's a standardized or simplified exemption. What has really changed is who is eligible to be considered for an exemption. So that's very important to understand, is the exemption process itself has not changed. It's again, who is eligible. So when you're looking at the standardized exemption process, prior law had a significant list of criminal convictions that were considered to be non-exemptable. And again, as I said earlier, what SB 354 has done is really align that to be more in tune with the federal standards. So now with this, through the passage of this legislation, those an RFA or a TAW applicant or anybody associated within those homes may be eligible for an exemption if 10 years have passed since the date of conviction for any of the crimes that are specified at that Health and Safety Code. So this is, for state non-exemptable crimes. It's very important to note. As I said earlier, when I use the word relative, it's deliberate. When we're saying state or federal, that is also deliberate. Prior to SB 354, there was a whole list of state lifetime non-exemptable crimes. So with 354, we have eliminated that. And many of those state non-exemptable crimes now have been eliminated or more aligned with the federal Adam Walsh Act. But again, 10 years need to have passed for those convictions that fall under those health and safety codes. With the simplified process, the simplified exemption process, what really changed with that is the number of years where a simplified exemption process may be considered. So it used to be for any misdemeanor convictions within the last 5 years, it is now within the last 3 years. And then for felony convictions, anything that happened, it was 7 years, it's now within 5 years. So if you meet the other simplified exemption process, that's all outlined in the background assessment guide. Instead of that 5 and 7, you can now be considered for a simplified for a within 3 or 5 years. So we included this slide here. This is really an example of one of the sections in the background assessment guide. And I wanted to include this today just for folks to kind of see what the background assessment guide looks like. So this is from section 111A about state non-exemptable crimes. And it's related to this penal code, sexual battery. And you can see now under the second bullet, it spells it out to you pretty clearly that if it was a misdemeanor conviction, it may be exemptable after 10 years. But if it was a felony conviction, let me see if I'm reading this right. Okay, yeah, only exemptable after 10 years if convicted of a misdemeanor. Felony convictions would be non-exemptable, are still non-exemptable. I'm sorry, I'm looking at this want to make sure I've got my words right. So we use this as an example to show how we've updated the background assessment guide and how we've made it as user-friendly as we can. And we make sure that they are updated anytime there's changes to what has occurred with legislation, or we've found some areas that need correction, we update those very quickly. Next slide. So under this, this is now for criminal background checks, and it's specific to the resource family approval process and for relatives. So this, what we're going to talk about on this slide is not something that's eligible for a family going through the tribally approved home process or for non-related extended family members. It's specific to relatives and are going through RFA. So here it says that if a relative has a state or federal non-exemptable conviction, they may still be considered for an exemption, and they can still be approved as a resource family. So this is a significant change, because if you had a state or federal non-exemptable, that used to be it. The process was done, the family would have to be denied approval as a resource family. But if you are a relative now, even with this non-exemptable conviction, you could still be considered to be granted approval of that exemption and then move forward with the rest of the RFA process and could ultimately be approved. It does not, what this provision does not do is it does not entitle anyone to be granted the exemption, but just gives them that opportunity to request an exemption, and then they still go through the standardized exemption process to present rehabilitative evidence. However, there is a caveat to that, and that's if you're going to be eligible to request an exemption, there can be no felony conviction within the last 5 years of any of these following crimes: child abuse, spousal abuse, rape, those lists. So those still would have to wait at least 5 years to be considered for an exemption. However, if it's been at least 5 years, 6, 7 plus years, then yes, that relative could be considered for an exemption even in these categories. Again, going to stress that you're given the opportunity to request and be considered for one. It does not mean you're automatically granted. You have to go through the full exemption process here. In these situations, when a relative has been granted approval as a resource, has been approved as a resource family, because they were granted an exemption for a federal non-acceptable crime, the approval must be child specific. So this family can only be approved for a specific child that's been identified when the criminal exemption that was granted was for a federal non-exemptable crime. Thanks, Emily. So again, child-specific approval, this is something that is specific to the Resource Family Approval Program, and it can be found, more specific details about it can be found in the WIC code here and in the RFA written directives. So we wanted to talk about child-specific approval a little bit in more detail here, because there have been 2 significant changes about when a family is eligible to would be considered for child-specific approval. One of the questions we get oftentimes from counties is, what if the relative does not want any other child in their home? They're only interested in having placement of this specific child. And what we really need to help everybody understand is that's okay. They don't have to accept placement of anyone else. But unless they fall under one of these 3 bullets here, the child-specific approval cannot be the default approval for relatives. So unless one of these buckets occur here, they would still be approved in the more general sense for resource family approval. And in those situations, you would approve them for a capacity of 1, if that's all they were interested in. And there's other areas we could go into more detail at another time to explain why this is important. But it is for the family's benefit and for the county's benefit as well, in terms of what you would do if they wanted to open up their home to additional children. The only 3 times child-specific approval should ever be used in RFA, though, is number 1, and this is the one that's been around for a while now, for several years, is the familial or tribal relationship is of such significance it outweighs any concerns that were identified through the family evaluation. So what that really means is when you're assessing a family, this relative, maybe there's some issues with their health, or there was some type of issue that you identified that in general, you may not seek approval for them as a resource family. They may be going down the route to be identified, but the relationship is of such significance, it does outweigh those concerns, and it is important to approve that family. The second area where you could do a child-specific approval, and this is one of the newer areas through the passage of AB 686, is that the prevailing social and cultural standards of the Indian community have been applied to the specific Indian child. Version 8 of the written directives is currently being worked on. We anticipate that will be released in September, and we will have a lot more guidance and information available to everyone about the implementation of AB 686. This is an exciting new opportunity where the collaboration is occurring with the tribe, and there are situations with the family going through the RFA process if being considered for an ICWA eligible child, where you're going to apply the prevailing social and cultural standards as established by that tribe for that family and that child in that moment. In those situations, you would also use a child-specific approval. And the third one, as we've talked about with SB 354, is that the relative has received a criminal record exemption pursuant to the Health and Safety Code. And again, that is where the relative has received an exemption, been granted an exemption for a federal non-exemptable conviction, but they still were granted it and went through the RFA process and were approved. In that situation, it is a child-specific approval. It's also important to note, though, that approval and placement are still very separate decisions made by separate entities. So even if you are granted child-specific approval, the child's worker, the placement worker, still has the ability and the right to make that determination if this child should be placed with this family. So they're still done by child staff for the child decision, placement decisions, along with the court. The RFA worker is still going through the RFA process, making the RFA approval determinations. They work together, but they're separate decisions. So just because you're approved does not guarantee initial or continued placement of a child. Okay. So then petition for reinstatement. So we do understand that there were potentially many individuals who had gone through the RFA process who were denied a criminal record exemption because of a conviction that was non-exemptable, but now might be potentially something they could be considered for an exemption. In these situations, if that individual had appealed the decision prior to January 1st, 2022, if they were denied a criminal record exemption and they appealed that decision, they may have been excluded by the California Department of Social Services. And if a lifetime exclusion order was issued by the department because of a conviction that's now potentially exemptable, they are eligible to request an exemption now as a result of SB 354. What they would need to do is petition the department for reinstatement after 1 year has elapsed from the effective date of the exclusion order. So it'll be important to look at what the date of that exclusion order is. They will need to wait for that 1 year mark, and then they could apply again. In the background assessment guide, we have a lot more detailed information regarding petition for reinstatement. We know there's a lot of questions about that. We want to ensure that families who have the opportunity to reapply are able to do so within the scope of the law and what we're able to do there. So please, if you've got families that you have in mind, please look at that section of the background assessment guide. At this point in time, we're going to turn it over to the Care Provider Management Bureau, who's going to talk about the process they go through when they're working on doing background checks for foster family agencies. And I believe, Yosaida, you're going to be discussing this?
Yes. Hi, everybody. My name is Yosaida. I am an analyst with the Care Provider Management Bureau. And I just wanted to provide you with a few tidbits of information regarding how notifications are sent from CPMB regarding background checks and provide you with a tool to track background checks that we process. So in regards to how CPMB communicates background check decisions, we've kind of broken it down into two different categories. The first being agencies who do not utilize Guardian. And for those of you who do not know what Guardian is, it's just an online background check system that we launched in January 2021. Again, so the agencies who do not utilize this database are being notified of background check decisions by a letter via mail. So this could include clearance letters or exemption approvals. On the flip side of that, for agencies who do utilize Guardian, the system does send electronic notifications. And what an electronic notification is it's essentially an email notifying you that a background check decision has been updated. So as an agency, you're able to log into the database and retrieve any letters from the system and also view the status of an individual. For instances where an exemption may be needed or an exemption is denied, those notifications will still be sent in the form of a letter for both agencies who utilize the system and agencies who do not utilize the system. So with the implementation of SB 354, CPMB is currently working on some detailed instructions on how to fingerprint applicants for child-specific exemptions. And the communication will come out in the form of a provider information notice, or other words, a PIN. And just as a reminder, you can find out more published on the Community Care Licensing webpage. Now, jumping towards the bottom of this page here, we do have a resource for you, which you can use if you're an agency utilizing Guardian or not utilizing Guardian, but it's our background check search site, and we provided the link here for you as well. What this is essentially it's just a public-facing website where you can search for an individual and get the status of their background check. So we put, it may be a little difficult to see, but there are some red asterisks on the snippet to the left of the slide here. All you will simply need to do is enter in the 9-digit licensing number that the individual fingerprinted for, their first name, last name, and date of birth. And then once you click that search button towards the bottom, you'll be routed to their background check result. For this example here, I put a box around the status. It does say just determination status eligible. And essentially what an eligible status means is that they've passed all of the statutory requirements for their background check. And CPMB has just deemed them eligible via a clearance or exemption. Another status you may see commonly on this page is an in-process status. And in-process is just another way to say that they're pending. There could be a variety of reasons why an applicant's pending, but probably some of the most common ones are they may be going through an exemption process with CPMB, or it could simply be that the fingerprints are pending with the Department of Justice. We'll go to the next slide, please. Thank you. So on that note, we have provided CPMB's contact information for you. If you have any questions regarding the status of a pending case with us, you can utilize our customer service options. We do ask that you wait 30 days before following up on a pending case. However, you can utilize our phone lines, which our number is published here at the top of the slide. Our phone lines are open Monday through Friday, 8 a.m. to 12 p.m. And this excludes holidays. I just want to also point out that our phone lines do close at noon, but if you are in the call queue before noon, just kind of stay on the line, and operator will answer your phone call. We also provided our mailing address here. If you want to provide us with any of the background check documents that are needed, you can mail them to us at the address provided. And then at the very bottom, we just provided our customer service email address, guardian@dss.ca.gov. If you'd like to email a question, you can email that specific inbox. Or for any login issues, we've provided our login support team as well. So with that, I'll go ahead and turn it back over to you, Kim. Thank you.
Great, thank you. Okay, so we've so far talked a lot about SB 354 and the criminal background process and how it's been impacted by that. And I'm sure many of you now are wondering, when we have relatives being approved with a federal non-exemptable crime, how is that going to impact their funding? So this is what we're going to talk about next, is some of the different funding options that are available to our families now as a result of SB 354. Some of these are not new, some of them are already existing, and some have had some tweaks to them, so we'll talk about that a little bit more detail. So this slide is about the emergency caregiver funding. It's funding that is provided to families who received a placement prior to approval, and that could have been through an emergency placement after a 361.4 or 727.05 assessment was done. That's an emergency placement assessment that's done either on the child welfare or probation side. I like to remind people that probation staff can do emergency placements themselves with their children as, in addition. So emergency caregiver funding is available to any of these families. I don't think we have it on here, but the other reason where you might be able to have an emergency, receive emergency caregiver funding is if you received placement for a compelling reason. And that's an option that happens through the RFA statute when you have completed essentially half of the RFA process, and written directives go into more detail about that. You can also receive a placement prior to approval and receive emergency caregiver funding. But in order to do so, that assessment has to be completed. And I use the word completed on purpose because it doesn't mean that the recommendation was favorable, and I'll explain that in a minute. But as long as that assessment's been completed, the EA1, which is an eligibility form, has been completed, and the family, the caregiver, has either submitted an RFA application or initiated approval process with a tribe. If those items have been done, they're eligible for emergency caregiver funding, and it's available for up to 120 days, or if there's a good cause reason for the delay, it can be extended for up to 365 days. So this again is for RFA applicants or families going through the tribal approved home process. At this moment, our most up-to-date ACL regarding EC funding is ACL 21-88. We anticipate our next ACL with more updated information being released late September, early October. And really the information is mostly the same. Some good news with emergency caregiver funding is instead of looking at what's going to change every single fiscal year, because they were only allowing the funding to happen for one fiscal year at a time, it's now much more permanent, but the 120 days up to 365 will remain. What SB 354 has added, though, is if the family is not eligible for emergency caregiver funding, and again, that's if you've received a placement prior to approval and the court has authorized the placement, and that's an important component, the relative may receive ARC funding. That's the approved relative caregiver funding. So really important to know, we've gotten this question from a lot of people, is there is no change in how the courts provide, there's no change in how the courts prepare their findings and orders when authorizing a placement, but the counties will need to ensure that they've established your own internal policies, procedures on how you're going to communicate with the eligibility staff to ensure that the ARC funding is initiated at the appropriate time. So that's going to be important for eligibility staff to know that all the steps are met and the court has authorized the funding. Emergency caregiver funding is set at the basic home-based care rate. I don't know what that rate is right now, but it's only the basic care rate. Any of those additional level of care rates are not eligible for emergency caregiver funding at this point in time. And also important to note, though, is that only relatives may receive the ARC funding. And I'd like to stress that because through the compelling reason placement option, where a caregiver could get emergency caregiver funding, anybody can receive a compelling reason placement. It's not limited to relatives or NRFMs, but in terms of who can get the ARC funding, only relatives can. It cannot be a non-related extended family member or anyone else. It must be a relative. Yeah, next slide. Okay, so again, this is related to relatives only. So we've also received some questions about what to do when the funding is not, when they're not eligible for AFDC FC. So essentially, if a relative is approved as a resource family and they were granted an exemption, that's a federal non-exemptable crime, and the court authorized the placement, then the relative is eligible to receive ARC funding. And that rate can be determined by the level of care protocol. Because now they're an approved resource family, the LOCP would apply, so they could receive that level of care rate 1, 2, 3, 4. But again, these are in situations when they were granted a federal non-exemptable conviction. Would like to point out that if the child is 4E eligible and they end up subsequently not staying with this relative and they're placed in an approved resource family home who does not have a federal non-exemptable crime, then the funding would switch back to the AFDC-FC there. So this ARC funding is when those resource families have a federal non-exemptable conviction and they were granted approval as a resource family. Something else that was added into SB 354 is that if a relative is actually denied approval, and this is a big one, if a relative is denied approval as a resource family and the court authorized that placement to be with that relative, they are actually eligible for ARC as well. So in these situations, in this one situation only, the denied resource family approval applicant, if they're a relative and the court authorized placement, they can receive ARC. And the same situation would occur there. The rate would be determined by the level of care tools. The way the statute is, this only applies to RFA denials and not rescissions. And again, this is only something, an option available for a resource family, not the tribally approved home process. So these are situations where the family would receive ARC funding. Next slide. So funding for permanency options. We'll talk first about guardianship. So if guardianship with a relative is being considered or ordered by the juvenile court, state, and again, federal state is important here, state kin gap is available if the relative was approved as a resource family and they were granted an exemption for a federal non-exemptable crime. These are the situations where only state kin gap would be available to that approved resource family. If there is no federal or state kin gap available if the relative was denied approval as a resource family or as a TAW. That's regardless if the court authorized the placement. The reason for that is in the kinship, in the kin gap statutes, they talk a lot about, it all talks about being an approved relative caregiver. And in those situations, that relative is not approved. They were denied, so they are not eligible for any type of federal or state kin gap. But if they are an approved resource family with a federal non-exemptable conviction, then they can receive state kin gap. Adoption now, if adoption is being considered with a relative, they are not eligible for AAP, and it doesn't matter if it's federal or state AAP. They are not eligible if they were granted an exemption for a federal non-exemptable crime. This is information that we were able to get some more information on. We didn't have all our information at the time we released ACL 22-33. So we were able to follow up and clarify this AAP. So in these situations, there is no AAP available. Next slide. Okay, so there's some other important facets to SB 354 that we wanted to highlight on, and that is they included some language about AB 686 The language didn't change from what was in that bill, but it really stressed the importance of Indian community standards in RFA. So in these situations, when in the case of an Indian child, when the tribe is not exercising their right to approve the home, the county must collaborate with the tribe at all stages of the RFA process. And any cultural standard that is applied to the resource family must be determined by the tribe and applied in collaboration with the tribe. And it's only applicable to that specific family and that specific child. And as I said earlier, there's going to be a lot more detailed information released in version 8 of the written directives, which should come out in September. We worked really hard with several regional work groups, with our tribal partners, with counties, with FFAs to develop the guidance on AB 686. So more information will be coming out with that. Some other information with SB 354 is clarifying that there is no minimum income requirements in the resource family approval process. So that was clarified. It was stated much more directly than had been previously stated. There is a requirement that the family have financial stability, but there was never a requirement for a minimum income that a family had to have. And so that was clarified. And it actually went a step further because families do need to have ensure that there is financial stability within the family, but an approving agency can actually waive that requirement for relatives and NERFMs on a case-by-case basis. So it's not something you would waive across the board for all relatives within your county or within the FFA, but it can on a case-by-case basis be waived. And then SB 354 also set up some requirements for the department to collect specific data that is supposed to begin January 1st, 2023 regarding the criminal record exemptions. And in fact, a report to the legislature will be made based on some of this data. We have been working internally and we're reaching out to our partners as well to determine the best way to collect that data. An all-county letter and ACL will be forthcoming to further explain the details and instructions. So we will give you some more information on that very soon. We want to ensure that the data collection is meaningful, but not difficult to obtain or difficult to gather. So we want it to be as efficient as possible. And when we talk about approving agencies here, the approving agency is the agency responsible for the approval of the resource family. So that could be different than the placing agency. The approving agency might be an FFA, it might be a different county. Always important, again, to keep in mind that placement and approval are very separate, and it can be done by completely separate agencies. So I feel like I spoke really fast here. And I think our next slide, though, is about resources here. Really, maybe mark some of these as favorites. Bookmark them when you have an opportunity to do so on your computer here, especially the background assessment guide and the resource family approval written directives. Those, I mean, if you're actively utilizing RFA, or even if you're not actively using it, but you talk about it in some of your day-to-day work as a placing agency, it's so important to have that right there at your fingertips to really check, and don't assume you know the answer, look it up, especially when it comes to the criminal background checks. Always look it up in the guide. We can't stress that enough. We also like to remind people if you're printing it out, or you're just saving it onto your desktop, that you might not have the most current version. So it's really important to bookmark that as a favorite on your computer, so that when you're clicking on it, you're always going right to the most updated guide there. And you can see right now the current one is June 6th, 2022. And then we also know that we may not answer all the questions today. You may have very case-specific questions. So if it is related to SB 354, we have an email box there. Please send questions specific there. Same thing with RFA when it's regarding RFA. And then if there's questions regarding emergency placements and the emergency placement process, please send those to Child Protection there. So I think I got through everything, and I'm sure I haven't been looking at the chat, but I'm sure there's no questions, right?
Awesome. Thanks so much, Kim. We do have a few questions. So I think I'll read a few of those off now, and we'll get through as many as we're able to. And like we said, if there's any that we're just not able to answer at this time, or if we just don't have enough time to get through everything, we will send out the FAQ document once it's ready to everyone that's on this webinar. And I know that there's some hyperlinks being shared in this slide, so we will be sending out these slides following the webinar to everyone, so you'll be able to access those. All right. I'm going to apologize in advance if I get any of these acronyms incorrect. I'm not the most familiar with this topic, so I just in advance, I'm sorry. Okay, so Bridget asked, if the relative is a court-authorized placement, is it based only due to criminal history, or can it only be due to RFA denial and not criminal history?
Can you say that one again, please?
Absolutely. If the relative is a court-authorized placement, is it based only due to criminal history, or can it only be due to RFA denial and not criminal history?
So Kim, I'll help you out. So if they're denying,
I'm very visual and I'm looking for the question myself.
I think Bridget is asking if the court authorizes the placement, can it only be due to criminal history, or can it be authorized if it's because of the family valuation or some other reason for denial?
Let's see here.
It's in the Q&A, not in the chat.
Yeah.
And Kim, I just sent it to you privately, so you might have it most recently.
Okay.
And I can also, if it'd be helpful, if Bridget's still on, I can unmute her to see if.
I know, I'm sorry, it's because some of these are so technical. Yeah. In terms of court authorized placements, the court has always authorized placement. I know sometimes there's a little bit of different lingo, but there's not really been a change in courts authorizing the placement. It's more so in order, that they have the ability to authorize a placement where you can also get the approved relative caregiver funding given certain circumstances where that would not have been available. I don't think I'm answering the question entirely though, so I may have to take that one offline. I'm sorry, or look at it more carefully, unless one of my teammates is able to answer that more carefully than I can.
But I think you're right. I mean, the court has always been able to authorize the placement. I'm wondering if she's needing to be ARC eligible. Because we did get some other questions related to that. If the family is denied another reason besides criminal history, would they be able to get ARC funding?
Okay, I can go to the next one. The next question is a do not remove order considered a court authorized placement?
I think that's a question we would need to do a little bit more research on. My understanding is that with court authorized placements that, nothing should really change in how they've done that in terms of findings and orders. But do not remove that could be construed as more of a court ordered versus a court authorized. And there are some differences, there could be some differences there. So I think we may have to take that one off. I'm sorry.
No, that's okay. The next one, I'm going to go back to slide 9 briefly, and I can unmute Christine if that'd be helpful. She asked, can you give an example of this? And this question came in while we were on slide 9. Let me see if Christine is still on. I can see if I can unmute her. Okay. It looks like Christine is still on. I'll see if she can elaborate a bit more. All right.
Emily?
Christine, I unmuted you. Can you elaborate a bit more on the question that you had about slide 9?
I just wanted an example of a state or federal non-exemptable conviction that could be considered for an exemption. But then, and then at the second bullet, it says they can't be a felony conviction in the last 5 years for any of the following.
Mhm.
So just an example, I mean, of what.
So let's see
First
here.
bullet.
Yeah, so I mean, for any of those in the second bullet, if it's been within, if it's been more than 5 years, they could request an exemption. So if it's been 6 years since their conviction for spousal abuse, they can apply, they can request an exemption. And again, you'd go through the standard, all the standardized exemption process. For something that would not need to qualify within that last 5-year part, Charm or Kendra, can one of you think of an example there?
Yeah, okay, I'm understanding it better now. I reread the second bullet again.
No, it's, you know, it's going to be important for any of us. And as you see, when I'm hesitating quite a bit here, every answer is so nuanced that, I'm trying to be very careful with my words, which is making me stumble more than normal, I think, too.
Awesome. Thank you so much, Christine. I'm gonna put you on mute again. And the next question comes in. It says, can the court override the social worker's placement decision?
Absolutely, yes. The court has always had that ability actually to override a county's placement decision. What has changed can be a little bit of the impact of that. So for example, if the county completed all the steps to assess for an emergency placement and they made the recommendation not to place that child with that relative caregiver, maybe there was something that popped up on the CLETS that was of concern, so they chose not to make that emergency placement, the court can still go in and authorize that placement to still occur. And in that situation, they would actually be eligible for emergency caregiver funding. Same thing, you know, if they are denied approval as a resource family and the child's worker is determined, they're denied approval, I do not want to place the child here. When the court is informed of that, the court can authorize that placement to still occur. Specific to relative there, I should say. Yeah.
Thanks. All right, the next question is, if the applicants indicate they only want placement of their relative child and don't want to foster any other children, can we still approve them as child specific, or do we approve them as non-child specific despite their request?
So no, you would not, if they don't fall into one of those bullets, then no, you would not approve them as child specific approval. This is an area I know that has been very confusing for a while now with RFA, because in the old world, the approved relative process, it was pretty much specific to the child, but RFA is much broader than that. So unless they fall in one of those broad categories, you must approve them as a general RFA. It's just a general RFA approval. It would not be that child specific approval. What you would do is set them up with a capacity of 1. So that way, if somebody's looking in the system, they would see, oh, this family's full, so can't call them for placement. I mean, it's really important because in these situations, if a subsequent sibling comes into the system and it's a child-specific approval, there's a lot more work on the county's end and on the family's end to complete an update to the approval to see if their RFA can be increased beyond that specific child, or you know, or if they decide they really like doing foster care and they do want to go accept non-related children, which we've seen that happen in most counties, that would really hinder them. So it's important to only use those 3 bullets for child-specific approval. And I know a lot of folks may have questions about that because there's and we are talking about that more with CWDA about how to clarify and some of the unintended consequences of doing a general approval for a relative. Those are some things we're working out a little bit more with CWDA on to improve some of that. But legally and per our written directives, those are the only 3 times you should be doing a child-specific approval.
Awesome. Thanks, Kim. Okay. The next one is, how does SB 354 apply in the case of arrest-only investigations when a clearance is required? Do we follow the same assessment process?
I would suggest looking in the background assessment guide that would have been updated with arrest-only information as well. Unless Charm, do you have anything you would add to that? Is Charm able to go off mute?
I'm here, Kim. Hi, sorry. So the arrest-only investigation requirements are the same, but the non-exemptable or the crimes that fall into those categories of crimes that need to be investigated might be different. So like you said, you should look into, look at the BAG section 113, and then there's a hyperlink in there to the section of Health and Safety Code that talks about the crimes that need to be investigated. But it doesn't necessarily affect, well, it may, depending on the outcome of the investigation, but essentially the non-exemptable crimes list would be different, like the ones that you just went over for purposes of the arrest investigation.
Yeah, and you know, I don't think any of us can say this enough to please look at the background assessment guide. It's laid out in extreme detail about all the different codes of what is exemptable, what is non-exemptable. That's where you're going to really look to for a specific answer to what may or may not be exemptable.
Thank you. All right, and the next question we received is, what if the caregiver does not follow through with the RFA process? If the court makes an emergency placement regardless of the, sorry, in advance, the CLATS or county recommendation? That's the question.
Okay, can you read it one more time? I'm sorry.
Yeah, absolutely. What if the caregiver does not follow through with the RFA process if the court makes an emergency placement regardless of the, is it CLETS?
Yes.
Regardless of the CLETS or county recommendation.
So the family would be eligible for emergency caregiver funding if those steps had been taken and an application for resource family approval has been received. So in those situations, they would be eligible for the EC funding for 120 days. After that, the county would have to determine if there's a good cause delay for it. If the family has chosen to no longer cooperate, that would be part of the assessment process and could lead to a denial. And if they were denied approval and the court has still authorized the approval, yes, in those situations, they could receive ARC funding. But if they never submitted an RFA application, then the answer is no, they cannot, they would not be eligible for EC funding or ARC funding. It's very clear you have to initiate to get the EC funding, and it's very clear you would have to be denied approval as a resource family. And really, we want to ensure that families go through the approval process and that we work with them if there are concerns, if there are issues, to try and mitigate it. If the family is denied approval, there is no RFA standard that they're going to be following. There is no complaint allegations that would be made against the family because there's no violation of a written directive. So, it's important to look at for the court to understand that the child's worker would still be going out and doing their caseworker visits and doing all the supports regarding the child. But in those situations, there is no RFA standards to apply to that family because they were denied. So it's something we want to look at carefully and not encourage families to just drop out. We want to make sure that all the supports and services are in place for our families and for our children when they're going through the process here. I lost sight of what the original question was now, but they do have to, submit an RFA application and or be denied approval or approved to receive funding. I think that circled back to the question.
Thanks, Kim. All right, the next one is, does the SB 354 also apply to relatives with a 211 robbery charge?
I would say, I mean, that's a specific charge that I'm not familiar with, but if it's a federal non-exemptable, yes, they could be considered for a criminal, to be granted a criminal exemption for that. I don't think that's one that would be on this list within the last 5 years. And it's potentially, depending how many years since that conviction, could be something that any applicant is eligible for if it's been more than 10 years. Charm or
Kim.
Dodge, I was going to say, please contradict me if I get anything wrong, because I do not know what a 211 is.
Sorry, 211 is robbery. So that would be under the federal non-exemptable crimes. So if it was a relative, they would have to fall under this this little group of crimes in order to, you know, under the child-specific approval in order to be considered for an exemption. But it is a federal non-exemptable, so it wouldn't be something that any other applicant other than a relative could be granted an exemption for.
Thank you so much. Appreciate that. Yeah, always go to the bag for these specific codes.
Awesome. Thanks, Kim. Thanks, Charm. All right. Okay, the next one is, are tribes given forms to give to our family relatives to do the background checks through a county agency or tribal organization?
Charm, I hate to do this to you. I'm not sure what the process is
Right.
that tribes go through to have a county help with the fingerprinting.
So if a tribe, whether they're authorized through DOJ or not, if they choose not to do their own background checks, you would refer to ACL 1971. They would ask the county to, or CDSS, CPMB, to conduct those background checks on their behalf. There's no formal way of doing that. Some tribes will email, some tribes will do it on I think it's called a tribal resolution letter. It just depends on each tribe or tribal organization, but there's no prescribed format for requesting the county or CDSS to conduct the background checks for them.
Thanks, Charm. All right, the next question is, how will eligibility know if the RFA was approved with a federal non-exemptable exemption?
That is an excellent question. We are updating the RFA 05A, which is the certificate of approval, and it will include a box on that certificate that will be checked if the family was approved with that federal non-exemptable. In the meantime, it may be necessary for counties to develop some internal procedure for communication to ensure that the eligibility staff know in those situations. The forms are going through the final approval process now, so they should be available very soon. And again, Kendra, if I'm saying anything incorrect, please correct me, because I know you're taking the lead on that.
Nope, you're correct. It'll have an indicator on the certificate so that it says 354 exemption approval.
And that certificate is something eligibility staff already need in general, especially if they're for the emergency caregiver funding, to know when to switch aid codes. So that's very important that counties have a procedure to share when the RFA, to verify when the RFA application has been submitted. Eligibility needs to know that, and they need to know when the family has been approved, and again, when it's been approved with a federal non-exemptable, and or when they've been denied. So I don't want to leave out the denial part. That situation may occur a lot less, but important for them to know as well.
Thanks, Kim. Thanks, Kendra. All right, and our next question is, does the denial have to be a criminal exemption denial or denial for any reason? Our fiscal interprets that it has to be a denial for criminal exemptions, only would ARC apply.
At the moment, I would like to look at that a little more closely. I think I know the answer, but as I keep telling you guys not to assume you know the answer, but look in the bag. Let me confirm that one.
Thanks. So we'll
somebody knows from our team directly for sure.
That's not in the bag, Kim, but if you look at the ARC statute, I think it's at 11461.3 subdivision L, it just
Yeah.
says, it doesn't specify a reason. It says that if they're ineligible for AFDCFC due to denial of RFA, they would qualify for ARC. So there's no specified reason.
And that was the answer I believe is true. Yeah, so thank you. I'm not able to obviously look everything up real quick. If you're just denied approval across the board and the court authorized placement.
Correct.
All right. Kim, just let me know. I think some of these, again, not being an expert in this area, some of these might be a little bit redundant. So just let me know if it's something you've already spoken to. If the relative is not eligible for EC funding and the court authorized placement, a relative may receive ARC funding, but is that rate determined by level of care?
Because they're not approved yet. That is a great question. I think and no, that is slightly different than some of what we talked about in the funding slides. We will follow up on that. I don't have a specific answer on that.
Great, thank you so much. And yeah, we'll be sure that that's in the.
Actually, I had not thought about that one yet, so thank you. See, every day where there's another twist and turn to look at with SB 354. It's a good thing.
That came from Alyssa, so thank you, Alyssa, for raising that. All right. Someone asked, so what are they getting for payment if no AAP? Is that enough to go off of?
I mean, this is why it's very important to have communication and make sure that the courts are aware. They can apply for CalWorks as a legal parent could apply for funding, but if they're adopted and they have a federal non-exemptable, there's no AAP, so it's whatever any legal parent out there could apply for funding. So it's a very important consideration before parental rights are terminated, that conversation is discussed with the family and with the courts, because there's a lot happening, and the juvenile courts do a great job of keeping up to speed. But when it comes to areas that aren't impacting their day-to-day work, they may not understand that all the time. So look at that very carefully before you terminate parental rights, because there might not be any funding unless the county chose to fund a family, but that would be post-dependency.
All right, and our next one, if a home is rescinded, are you saying the family is not eligible to get ARC if the child is court ordered to remain in the home?
That's correct. The statute says only for denials. It did not include rescissions when this bill came through. Now, SB 354 was a large bill, and it went in, I won't say it went through quickly. It was worked on heavily by the authors and sponsors. There was a lot of conversation about it. Oftentimes with large bills like this, though, sometimes it's discovered later areas that might need additional cleanup. So I'm sure that the authors and sponsors are looking at any ideas, if they did need to do some cleanup, that could be something that they might look at. I'm not sure. But the statute was very clear. It only said denial.
Thanks. All right, and our next one is, what are the permanency options for children who are placed with caregivers who are not RFA approved, but via court-ordered placement? Can the caregiver adopt?
The caregiver can always adopt. If they go through the adoption process, and if they can still move forward to adoption, if the court chooses to grant the petition, it's the funding that is impacted. So the court can still order adoption. The court can still finalize that adoption. What is impacted is their ability to be eligible for AAP.
Okay. All right, and our next one, another question on adoptions. Are RFA denied relative homes no longer eligible for adoptions?
That is an interesting question, and it's a little more complicated to answer, so I might not be the best one. In short, they could still move forward with adoption even with a denied approval as a resource family, as long as some other criteria are met. We will work, if I can say that word correctly, we'll work with our adoption policy folks to provide a more expanded answer to you on that. And I think they have some ACLs from the past that might explain that in more detail.
Great, awesome, thank you. And yeah, again, we'll be sure that that's included on the FAQs that go out.
Yeah.
All right. Okay, this one says, what are they relying? What are they relying on? Only the child's income, question mark? So I don't.
Wondering if that is based about the financial stability. So if it's about the financial stability, that is actually part of the RFA process. So when an applicant has applied to be a resource parent, one of the standards is that they are ensuring that they have financial stability in their lives, notwithstanding the additional cost that it has to have a child placed in their home. So just in general, if they had no children placed in their home, what does their financial stability look like? But it's based on their financial budget, income, expenses verification, not on the child's. That it's just a part of the RFA process. What changed with that is the ability to waive that stability requirement for a relative, and just clarifying that a family could earn $0 and still be considered for approval as a resource family, because there was never a minimum income requirement. But yeah, family, not child in this instance, if that's what they meant.
Awesome, thanks. Okay, so this next one says, any cultural standard that is applied to the resource family must be determined by the tribe and applied in collaboration with the tribe, and is child applicable only to that specific family and that specific child. So then the question is, how does that work if the approval is not child specific and there are other children from the same tribe later placed in the home?
So let's see here. That is a great, I do understand the question. And let's see here. Kendra, have we explored that? I feel like we have.
So an approval via 686 is a child-specific approval. If other children from the tribe are placed, then there may need to be an update, and that is something that we are still working on. Still working on if other children are placed.
Yeah, so I think it's also if they're wanting children that are not ICWA eligible placed in the home, I mean, they'd have to do an update, but that's sort of an interest, yes.
Yeah.
Let us take a little bit of a deeper look, and that might be an area that we need to further explore as we continue our evolution of AB 686 and 354. It's a great question. I just want to be very careful in how we respond to it. It's important.
Yeah, absolutely. Thanks, Kendra. Thanks, Kim. Okay, and this one we might have to circle back on as well. It says, what is the legal citation for the definition of relatives as it relates to the tribal community?
So that is, I don't have everything in front of me, but there, in terms of SB 354, everything but except for the funding pieces, and again, Charm, Kendra, you know, correct me if I'm going off the wrong direction here. The definition of relative in some of the situations of SB 354 is the expanded definition that would include extended family members. I think that's through WIC 319. However, the funding part of SB 354 that defines relatives did not use that cross-reference, so it does not include the extended family member definition of a relative. I forget what that WIC code is. I'm sorry. So that is something that, you know, we've had to take a deeper dive in, and that is the conclusion that's come up. So that's a hard one to hear, I think, for many people, because we do have many different definitions of relatives out there. So there is some conflict with that within the bill. Charm, Kendra, anything else you'd add or correct me on?
I would just add that the definition of extended family member, which are for tribes at 1903 of the USC code, that's the ICWA. That one also includes some of the California's definition of relatives. So like, you know, grandparents, uncles, aunts, siblings, those are also included in the ICWA definition. That's actually in WIC T24.1. So some of them overlap. I mean, California's definition at 319H, like you said, Kim, that one also includes that that language, affinity within the 5th degree of kinship. If any of those individuals under the ICWA definition of extended family member overlaps with the California definition of relative, then they would qualify. So, so in general, a lot of the individuals under the extended family member definition would overlap with the California definition of relative, if that makes sense.
And I'll go ahead and add that this is one of the questions we're preparing on our FAQ, our frequently asked questions, that we will send out. So you can see something that's more in writing versus us trying to explain, because the definition of relative sounds easy, but it's not in California. Maybe it is in other states, I'm not sure, but we've included this question as part of our FAQ. So you'll have a much more detailed answer there.
Awesome, thanks. I think we'll do one more and then we will wrap it up for the afternoon. So the last question is, I think the question we need answers is related to ARC eligibility with an RFS denied home. Does that denial need to be for a specific reason, or is it any type of denial?
So I think that's similar to the question we asked earlier, and based on what Charm was able to look up and read, that there is no specificity in terms of what the reason for the denial was. So if the relative was denied approval, regardless of the reason, and I'm always going to stress, and the court authorized the placement, then yes, that relative could receive ARC funding. When the courts are authorizing the placements, they are relying on information that the county has provided to them. So they would receive a summary of the information about the caregiver to help inform their decision. So I just want to reassure people that when courts are authorizing the placements, they're not doing it willy-nilly or just, you know, not learning anything about the family. I'm sure we know that, but it's I'm sure the courts will be looking at that very carefully.
Awesome. Well, thank you so much, Kim. Thanks for all the information you provided today, and then for sitting through these questions and providing additional information on that. And thank you again to everyone for joining. We expect me to send out a copy of today's PowerPoint slides. I'll probably send those out tomorrow morning to everyone that was on today's webinar. Kim and her team will continue to work on the FAQs that we referenced a few times today. Those will also be sent in the coming weeks to everyone that was on today's webinar. And then again, we have recorded today's webinar, and you can expect to see that on the CDSS YouTube page. And we have to make it accessible before it can be posted to the public page. So that usually takes about 2 weeks. So keep an eye on that.
Emily, I'm sorry to interrupt. We'll be able to track all the questions that came in that we weren't able to get to today, correct?
Yes, absolutely. Yeah, we looks like there's a couple more coming in, and I'm gonna stay on to save the chat. And so I've saved the ones that I read off, and a couple that we didn't get to, but it looks like a few more just came in. So we'll be sure to save the chat.
I want to make sure we didn't forget anyone's questions.
Yeah, definitely. No, that's really important. All right. Well, Kim, Kendra, Charm, if anyone has anything to add before we wrap up. But if not, we can go ahead and wrap it up.
Thank you so much, everybody. And again, we're here. We want to continue to help wherever we can. It's a large bill and a lot to take in. So thank you.
Yes, thanks again, everyone. Thanks for joining. Mhm.